Good evening.
Howdy. This is the third video this weekend, isn't it?
My goodness.
It's been a little while since we've done 3 in a weekend.
It's been a busy weekend.
Yes.
Hope everyone is doing great. We just had something come in and we wanted to do a video about this earlier, but Shiloh's graduation party kind of got in the way of it. You know how that goes.
Yeah.
But I had a couple of people send me the link to this, and we thought it was something that we should cover.
Yes. And before we get into the topic of this subject, I want to read something from a familiar book. We were all indoctrinated with the Watchtower songs.
Is that the one with the phallic symbol on the back?
Well, yes it is. By strange coincidence. Song number 10, Jehovah's Witnesses. It's entitled, Here I Am, Send Me. It's pretty interesting with verse number 2. I'm not going to sing it, I'm just going to read it. Men make the taunt that God is slow. The fear of God they do not know. Some worship idols made of stone. Some would put Caesar on God's throne. Who'll tell the wicked what's in store? Who'll warn of God's great final war? Lord, here I am, send me, send me. I'll sound the warnings fearlessly. No greater honor could there be, Lord. Here I am, send me, send me. I find it interesting that you Jehovah's Witnesses will sing this song and you'll indoctrinate yourself that the warning you're giving is to the world at large. What you fail to comprehend is what's happening among the governments right now in banning Jehovah's Witnesses, looking at the Jehovah's Witnesses in your policies regarding hiding alleged child abuse, allowing your elders who have been internally found guilty of child abuse to continue to serve as elders. And I know that the more that this gets exposed, you Jehovah's Witnesses are going to be looking at it from the perspective that you are being persecuted by the government. Here's a factoid for you Jehovah's Witnesses. What your organization fails to do in protecting children as regards sexual child abuse, the governments have to do it because you won't do it. The fear of God they do not know. You answer me a question. Why are these governments doing this? Is it because they fear God? Apparently not, because they're going after religious institutions and exposing them for who and what they are. They're the wicked. You're being told what's in store. Now I know that you Jehovah's Witnesses by far and large have not looked at the Australian Royal Commission because you have this indoctrinated fear that this is apostasy. This is going to be persecution from the governments. The governments are stepping up to protect children, something you won't do. And unfortunately for you, Jehovah's Witnesses, the governments are going to be forced to levy sanctions upon these religious institutions, and you are going to be one of them.
Exactly. Now, we have a video here. Now, this is from Justice McClellan. Now, we all might remember him from the Australian Royal Commission. Now, he gave a speech to the National Council of Churches, the Royal Commission into Institutional Responses to Child Sexual Abuse, and he was the chairman. Now, This is from the Australian Broadcasting Channel, and it's a video, and it's not the greatest quality because I wasn't able to grab it. I had to actually use my camera and record it off of my computer, so I apologize for that. But I'm going to put the link down below so that you can go see it if you wish, you know, in the high quality. But I just want to mention the article here that comes with the video, and the title of the article is Child Abuse Royal Commission, Justice McClellan warns churches to change or risk illegitimacy. Now, after we do this introduction, I'll play the...
Just let that sink in for the Jehovah's Witness. What does it mean to be illegitimized, Jehovah's Witnesses? What does that mean?
Illegal?
Illegal? Another ban?
Well, I was going to say, this is what Russia started with. They illegitimized Jehovah's Witnesses in Russia, and then we all know where that went. So, many of us who have been doing activism and, you know, applauding the Australian Royal Commission, well, if they illegitimize organizations who don't change, is that one step closer to being banned. So this is all what we have been wanting. This is all what we have been working for. And like I said, I'll let you, you know, listen to the entire speech he gives without any interruptions.
And look at the number of the percentage. He breaks down the percentage of what is involved with the child sexual abuse in Australia. What percentage of it comes from religious entities? What percentage of it comes from the political side of child abuse and things like this? And it's shocking that the religious aspect of the sexual child abuse comes from the religious institutions, and Watchtower is very much part of that.
Now I want to read a quote here that is going to be in his speech, but I just want to, you know, mention this quote just in case you happen to miss it. The community will not accept the legitimacy of any institution which does not give priority to the safety and well-being of the children for which it has responsibility. So this is actually a good thing because we have all been working to get Watchtower, getting the world to recognize that Watchtower is a pedophile paradise. And they mention about turning all these files over to the authorities.
Yeah. You have to realize, Jehovah's Witnesses, this illusion of persecution would not be coming upon you people if you were already protecting your children from child sexual abuse. And the very fact that you have the two-witness rule in place, and go back to the Australian Royal Commission on the redress. We couldn't find it, but it's in there. Your organization is not going to change the two-witness rule. So right here, this gentleman, Justice McClellan, has already warned, if you don't make the changes that are necessary, you will be illegitimized. You should have already been doing this, Watchtower, taking drastic steps to protecting the children that are in your care. And let's just face it, Watchtower, you claim to be the spokesperson for God. You're God's only channel to mankind. I mean, after all, you've got the 144,000.
They're the guardians of doctrine.
Yeah, exactly. You've got the governing body. Maybe this is God using the government to turn on religion. And your religion is among the religions that are getting turned on, Watchtower. So Jehovah's Witnesses, that ought to tell you that if God is putting it in the hearts of these governments to turn on religion, and they're turning on you, you're part of the same institution that belongs to Satan. You're getting your warning, because this abusive nature of this organization, you're shunning family members, your two-witness rule that hides child abuse. This is wicked activity. God can't approve of this, so he has to allow it to be destroyed. Sorry about your luck, Jehovah's Witnesses.
Yes. So this is what we've all been working for. We're very happy to hear this. And
I understand there's more to come towards the end of the year, too.
Yeah, he mentions something about more coming. So, and we do know that they have gotten a lot more child abuse cases brought to them. And he talks about having private sessions with victims in here. So, you know, I strongly suggest you listen to the entire speech because he updates basically on what the commission is doing. So this is excellent. Yep. This is excellent. And just remember, Jehovah's Witnesses is part of this. And if they do not change, they will be illegitimized, which is that close to being banned.
Yeah.
So another country going after Jehovah's Witnesses.
Yeah, and, you know, hopefully the United States will find the, will get rid of the yellow streak down their back and haul these people before the United States government also.
Yeah. Yep, exactly. Now, I wanted to mention real quick here in the article, it says, what is a royal commission? The highest form of public inquiry commissioned by the Australian government into matters of great national importance. So it's the equivalent of what the United States would have like a Senate hearing.
Yep.
So.
National importance.
Yes.
They're taking steps to protect their nation from abusive institutions. And religion is one of them.
Yeah, and it's a very good speech by the commissioner here, the justice. So thank you, everybody, for listening, and plaster this everywhere because this is really good. This is very good news. So hope you all have a wonderful evening and a wonderful week, and you all take care. Good night.
For inviting me to address your conference today. I'm sorry that I'm unable to deliver this address in person. Unfortunately, the other demands on my time have made that impossible. I last spoke to you in September 2015. Since that time, the Royal Commission has held a further 25 public hearings. That brings the total number of public hearings to 57. Our public hearing program concluded in March this year with a discussion of the nature, cause and impact of child sexual abuse. Our public hearing program was extensive. We examined more than 1.2 million documents. We heard evidence from more than 1,200 witnesses. The Commission has sat for more than 440 days. Hearings have been held in every state and territory and in a number of regional centres and towns. In addition to the hearings in which we sought to understand the conduct of individuals and institutions, the Commission has conducted public hearings with a policy focus. These include Case Study 24, Out-of-Home Care, and Case Studies 38 and 46 into criminal justice issues. Towards the end of last year, and through the first few months of this year, we held a series of review hearings. A number of institutions, including some faith-based institutions who had previously been examined in a public hearing, were invited back to discuss their responses to our findings. The Commission also held a hearing into the current policies and procedures of Commonwealth, state and territory governments in relation to child protection and child safety standards, including responding to allegations of child sexual abuse. Public hearings have a significant role in driving institutional and regulatory change. Many institutions who have not themselves been the subject of a public hearing have already responded to the problems revealed in similar institutions and have implemented changes or reviews to improve the safety of children in their care. As of this week, 33 case study reports have been published. The remaining case study reports will be published in the coming months. The Commissioners have continued to hold private sessions with survivors. For those of you who may not be aware, a private session provides an opportunity for a survivor or a survivor's family member to tell their story of abuse to a Commissioner in a protected and supportive environment. It is the primary way for the Commissioners to bear witness to the abuse and trauma inflicted on children who suffered in an institutional context. The Commissioners have now held more than 6,700 private sessions. Some of you may be aware of our extensive research and policy development program. This program has had the assistance of national and international experts across many disciplines. The program has 4 broad areas of focus: prevention, identification, response, and justice for victims. The Commission has now published 44 research reports, but for the resources given to the Royal Commission, much of this research would never have been undertaken. These reports are an important part of the Royal Commission's legacy. We have also published consultation papers in relation to criminal justice, records and record keeping, out-of-home care, complaint handling and response and redress, and civil litigation. I have now referred 2,025 matters to the authorities, almost always to the police, with a view to the possible prosecution of an offender. At this stage, we have been advised that there have been 127 prosecutions commenced as a result of these referrals. However, the volume of referrals is so great, it will take quite some time before all the matters are processed and prosecutions commenced. When I spoke to you last time, the Royal Commission's final report on working with children checks had recently been published. That report contains 36 recommendations. It is available on the Commission's website. The report in relation to redress and civil litigation was released in September 2015. That report contains 99 recommendations. In the redress report, the Commission has said that in order for any redress process to deliver justice, it is essential that there be equal access and equal treatment for survivors, regardless of the location, operator, type of institution, or continued existence or assets of the institution in which they were abused. For this reason, the Commission has recommended that the Australian Government should establish a single national redress scheme. We said appropriate redress should include 3 elements. Firstly, a direct personal response by the institution, including an apology, an opportunity for the survivor to meet with a senior representative of the institution, and an assurance as to the steps the institution has taken or will take to protect against further abuse. Secondly, access to therapeutic counselling and psychological care as needed throughout a survivor's life. This is a fundamental and most important component of any effective response to those who have been abused. Thirdly, modest monetary payments as a tangible means of recognising the wrong survivors have suffered. We recommended a set of principles by which redress should be funded. Those principles were: the institution in which the abuse is alleged or accepted to have occurred should fund the cost of redress. Secondly, where an applicant alleges or is accepted to have experienced abuse in more than one institution, the redress scheme should apportion the cost of funding redress between the relevant institutions. Thirdly, where the institution in which the abuse is accepted to have occurred no longer exists, and the institution was part of a larger group of institutions, or where there is a successor to the institution, the group of institutions or the successor should fund the cost of redress. We also recommended that the Australian Government and the state and territory governments should be the funder of last resort. with governments meeting any shortfall of funding for the scheme. We do not anticipate that there will be a large number of claims which will require the resources of a funder of last resort. The Commission has made the following observation about the responsibility of governments. I quote from the report. It says, "Although the primary responsibility for the sexual abuse of an individual lies with the abuser and the institution they were part of, we cannot avoid the conclusion that the problems faced by many people who have been abused are the responsibility of our entire society. The broad social failure to protect children across a number of generations makes clear the pressing need to provide avenues through which survivors can obtain appropriate redress for past abuse." On the 4th of November 2016, the Minister for Social Services, Christian Porter, announced the establishment of the Commonwealth Redress Scheme. In that announcement, Minister Porter said that any state, any territory, any church, any charity who has responsibility in this area will be able to opt into the scheme. Institutions would opt in on the basis that they fund the cost of their own eligible redress claims. The Commissioners understand that many churches and religious groups have indicated that they are positively disposed to the Commonwealth scheme. This is very pleasing to hear. The need for an effective response for survivors who have been abused in an institutional context is undoubted. The need to provide for their ongoing psychological and psychiatric care is urgent. The risk that a survivor's compromised health may have tragic consequences is real. It is unacceptable that we should not do what we can to minimise that risk. The recommendations made by the Commissioners in relation to civil litigation focused on 4 topics: limitation periods, the duty of institutions, identifying a proper defendant, and the principles for managing litigation. A number of our recommendations in relation to civil litigation have already been taken up by state and territory governments. New South Wales, Victoria, Queensland and the ACT have legislation that gives effect to the Commission's recommendations in relation to limitation periods. In fact, in New South Wales and Victoria, the amendments made to the Statute of Limitations go beyond the recommendations of the Royal Commission. We understand that Tasmania is in the process of drafting a bill that will give effect to the Commission's recommendations, and that the Northern Territory has approved preparation of a bill to the same effect. Western Australia told us that they are committed to introducing laws to give effect to the Commission's recommendations in relation to limitation periods. Queensland have now introduced model litigant guidelines specifically for child sexual abuse claims that apply in litigation to which the state is a party. They join New South Wales and Victoria in having such guidelines. In relation to the Commission's recommendations with respect to the duty of care of institutions, Victoria has introduced the Wrongs Amendment Bill to their Parliament. The bill provides that in a proceeding on a claim against the relevant organisation for damages in respect of the abuse of a child under its care by a person associated with that institution, the organisation is presumed to have breached its duty of care unless it can prove that it took reasonable precautions to prevent the abuse. It will be for the institution to demonstrate that they took reasonable steps to prevent the abuse of the child. As I mentioned earlier, we have now heard from more than 6,700 survivors in private session. To date, we have been able to analyse the information given to us by 6,302 of those survivors. 32% of survivors who have attended a private session reported abuse in a government institution. 10% of survivors reported abuse in a secular institution. 59% reported abuse in a religious institution. 37% of survivors who have attended a private session reported abuse in a Catholic Church institution. 9% reported abuse in an Anglican institution, 4% in a Salvation Army institution, 3% in other Protestant institutions, 2% in a Presbyterian and Reformed Churches institution, 1.3% in a Uniting Church institution, 1% in a Jehovah's Witness institution, 0.6% in a Baptist church, 0.5% in a Pentecostal church's institution, 0.4% in Churches of Christ institution, 0.4% in Seventh-day Adventist institution, and 0.3% in a Lutheran church institution. 70% of attendees who reported child sexual abuse in a religious institution were male. 30% were female. The average age that attendees report they were abused in a religious institution for the first time is 10.3 years. More than half, that is 51%, of the survivors who have attended a private session who reported abuse in a religious institution report being abused by a person in religious ministry. 22% reported abuse by a teacher in a religious institution. The Royal Commission's Criminal Justice Project is of a significant scale. The issues which we must consider cover a broad reach. One issue discussed in a number of case studies is the circumstance where abuse, although known to a responsible person in an institution, was not reported to the authorities. The criminal law does not generally impose a positive duty requiring a person to report. However, although unusual, it is not unprecedented. We know that it is often very difficult for victims to disclose or report what is happening to them at the time. We also know that children are particularly vulnerable. They are likely to have less opportunities to report to police and are less able to take effective steps to protect themselves. We also know that perpetrators of child sexual abuse may have multiple victims and may offend against particular victims over lengthy periods of time. Failure to report abuse to the authorities may leave a child, or perhaps a number of children, exposed to abuse. Reporting offences may be particularly important in an institutional context. Institutions may be conflicted. They have a duty to protect children, but they also have an interest in protecting the reputation of their institution. Imposing criminal liability for failure to report is likely to encourage reporting despite the damage this may inflict on the institution's reputation. Both New South Wales and Victoria have offences relating to failure to report. In New South Wales, there is an offence of concealing a serious indictable offence. In Victoria, there is an offence of failure to disclose a child sexual abuse offence. The Royal Commission is considering whether it should recommend that other states and territories follow the lead of New South Wales and Victoria, and if so, what might be the appropriate terms of that offence. As I mentioned, the majority of the allegations we have received have emerged from faith-based institutions. This inevitably raises the question, why? Why is it that in institutions which proclaim faith in God and embrace the highest ethical and moral principles, so many children have been abused? Why do some people who proclaim their faith and have accepted a life of religious endeavour breach their obligations to children? Is there something in either the structure, culture or personal qualities of members of the churches and other religious bodies, whether lay or ordained, that gives them such a prominent place amongst offenders? One matter is clear. When children are placed in residential facilities, whether an orphanage or a boarding school, access is more readily available to those with evil intent. This is true of any residential facility, whether run by a religious organisation or not. For that reason, as we know, the overwhelming majority of children are abused in a family context. The problems within families were excluded from our inquiry, but remain a complex and tragic problem which our society has not yet adequately addressed. Faith-based institutions also provide access to children. That access is available in an environment in which a child's spiritual development occurs and is nurtured by adults. Children are brought up to respect and to accept the instruction of adults. It is how children learn, both about themselves and about society. The child will always be vulnerable to the abusing adult. Where the adult is perceived by the child to be a manifestation of spiritual good, in some cases seen as having been especially chosen by God, and able to instruct the child about the mysteries of life, death, belief in God, and good and evil, an extra level of vulnerability may be present. The Commissioners have heard many times from survivors who as children were told that if they tell anyone about the abuse, they will be punished by God and may go to hell. Both physical punishment of the child and alienation from God are threats of which we repeatedly hear. Sometimes the child was told that the abuse inflicted upon them is God's will. Remarkably, some have been told that it is the way God wants them to learn about sex. The calculated exploitation of a child's innocence is difficult to comprehend. The power afforded to the adult by the institution is corrupted and used to abuse the child. The special attention which an abusing priest, pastor, or religious person may have paid to the abused child is commonly welcomed by the child's parent. This will also be true of a child's sporting coach, lay teacher, or dance instructor. That attention may engender a sense in the developing child that they are special. When the nurturing of a child's spiritual development becomes entangled with affection and misplaced adoration of the abuser, both the risk to the child and the impact of the abuse when it occurs increases. The loss of a spiritual life for a survivor is common, although not universal. For many survivors, this loss compounds the burdens they must carry for the rest of their lives. A pubescent or post-pubescent child seeking to understand their own identity and place in the world, including their sexual identity, is vulnerable to the affections and special treatment of the adult, leading ultimately to disillusionment and, for many, lifelong destructive consequences. The Royal Commission has undertaken the task of identifying specific elements that institutions should adopt in order to be child safe. This has involved an extensive analysis of available research and other evidence gathered by the Commission. A preliminary list of elements considered to be fundamental to a child-safe institution was identified. These elements were then tested in a research study that obtained feedback from a panel of 40 Australians and international experts. The panel agreed that the elements identified were relevant, reliable, and achievable. The research, which is entitled Key Elements of a Child-Safe Organisation, is available on our website. The Royal Commission's final report, which will be delivered to Government in December this year, will include an entire volume on making institutions child-safe. However, by publishing the research and disseminating the child-safe elements early, institutions are able to work on strengthening their child-safe practices without having to wait for our final recommendations. Many institutions have already taken them up and are incorporating these principles into their own operations. The 10 elements we have identified are: firstly, child safety is embedded in institutional leadership, governance and culture. Secondly, children participate in decisions affecting them and are taken seriously. Thirdly, families and communities are informed and involved. Fourthly, equity is promoted and diversity respected. Fifth, people working with children are suitable and supported. Sixth, processes to respond to complaints of child sexual abuse are child-focused. Seventh, staff are equipped with the knowledge, skills and awareness to keep children safe through continual education and training. The eighth principle is that physical and online environments minimise the opportunity for abuse to occur. The ninth, implementation of child-safe standards is continually reviewed and improved. And finally, policies and procedures document how the institution is child-safe. These elements apply to all institutions. It is incumbent on the leaders of those institutions to adopt these principles and ensure that they are followed. All who have leadership responsibility must inform themselves about the principles and ensure that their institution puts them into practice. I'm often asked by people whether I believe that much will change as a result of the Royal Commission. Do I think it has been worthwhile? Will institutions change is another question. Although in the early days of the Royal Commission the question could not be answered, I am now able to confidently give a positive answer. As we have continued with our work, we can already see fundamental change occurring in the way institutions are managed, with the introduction of many practices designed to protect the safety of children. Although there may be some people in some institutions who resent the intrusion by the Royal Commission into their institution, the overwhelming response is positive. What we can be certain of is that any institution which does not acknowledge past wrongs and the need for change will lose the confidence of Australians. The community will simply not accept the legitimacy of any institution which does not give priority to the safety and well-being of the children for which it has responsibility. I have previously said that the Royal Commission's work has changed the conversation about child sexual abuse in this country. As the Commission moves towards the completion of its work in December this year, the task which is posed to all of you is to continue to ensure that the institution to which you belong takes part in that conversation. Institutions must make the changes necessary to ensure, as far as may be possible, that children are not abused in the future.